afternoon. My name is Kelly Wiener, and I'm the managing attorney at Scott Legal. Thank you for joining us. We're going to spend some time today talking about E-2 visa options for difficult cases, specifically options where the investment amount is low or other types of risky cases. A few things before we get started. Some of you may know that this firm was founded on an E-2 visa several years ago. Our founder, Ian Scott, is in the U.S. personally on an E-2 visa and has also renewed the E-2 visa. Scott Legal is a full-service immigration firm, but focuses primarily on E-2 visas. We've processed hundreds of them, and although we've processed around the world at many different consulates, our primary two consulates are Toronto and London. We will continue our webinar series, doing at least 2 webinars a month on various different immigration topics. At the end of this webinar, we'll send out a few things. One is the PowerPoint you'll see today. Another is a comprehensive E-2 visa guide, and another is a link to where you can sign up for additional webinars. We're lucky today as a panelist to have Jay Wong, who's a senior associate at Scott Legal and has significant experience processing E-2 visas. If you have questions throughout the presentation, please send them to the chat box and we'll make time to answer those questions at the end. And finally, this webinar is being recorded and it will be made available on demand and will also be available on our YouTube channel, where we encourage you to visit this channel and also to subscribe, as we post many relevant immigration videos and on various topics on our YouTube channel. So without further delay, I will turn it over to GA to get us started.
Thank you so much, Kelly, and thanks everybody for joining us today. So why don't we get started with discussing first the E-2 visa requirements. So as many of you may know, the E-2 visa is a non-immigrant visa for investors who are seeking to come to the U.S. to develop and direct a U.S. enterprise that they have invested in. And the E-2 visa won't necessarily directly lead to a green card, but the E-2 investor can continue to extend the E-2 visa indefinitely as long as the applicant continues to meet the E-2 requirements. So let's go through the requirements. So the first requirement is that the applicant is a national of a treaty country, which means a country that has signed an economic collaborative treaty with the United States, and you can see a list of those treaty countries at our website. There's a blog post on it. So the applicant should be a national of that country, and that person should own 50% or more of the treaty enterprise, which means the enterprise that you will be setting up or purchasing in the United States. The investment, so each applicant must make an investment, which means you need to spend money on setting up the business or purchasing the business. This investment must be at risk, and which means you must have actually put the money to use such that the, whether you can recover the money is dependent on the success of the business, and the investment amount should be substantial. Now, this means substantial. There is no legal hard minimum for what amount of investment is substantial, but really in practice, this means you have spent everything, you made all expenditures that is necessary to get the business ready to start operations and get up and running. Now, there is also a requirement for the source of funds. Now, the source of the funds that the investor used to set up the business or purchase the business must be legitimate. So you need to prove where the money was sourced from. So for example, such sources can be saved earnings from employment income. It can be a gift, or it can be a loan from a bank, or a loan from a person that you know. The only requirement for loans is that the loan cannot be secured by any of the assets of the E-2 U.S. entity itself. So this means the loan can certainly be secured by other things, such as your personal property, real estate property, or things like that. Now let's talk about marginality. So the business cannot be marginal. What this means is referring to the revenue generation potential of the business. So the E-2 business cannot be what I would call a one-person shop. So the profitability of the business must be enough to not only support the investor and the investor's family's livelihoods, but also, and we recommend having enough revenue generation potential to support hiring 3 to 4 employees at least by the next 5 years of operations of the business. Now let's talk about the real and operating requirement. So this means that the business must be prepared to really hit the ground once the E-2 visa is approved. So for example, the entity itself must be established. It can be a corporation or an LLC, for example. And typically you would already have the business lease signed to have secured office space necessary for the business to operate. If a license is required to operate in a particular field, you would have already got the license to make sure that the business is ready to go. And also this can mean that you already have interest from clients in place. For example, you can submit copies of contracts that you have already signed with clients for the provision of services or goods, or letters of intent to retain your business for such services or goods. Another requirement is that the E-2 investor must be coming to the US solely to develop and direct the business. Now, and it is important to distinguish here that really the E-2 visa is not for someone who will be working as a solo practitioner in a field, right? So you won't be providing direct services as an employee or worker, but really your primary role as an E-2 investor will be coming in to manage and direct the business, and you will hire more employees to do this work. And finally, the last requirement is that the E-2 visa is a non-immigrant visa. So you do need to show an intent to return to your home country once the E-2 visa has expired. And this is usually satisfied by a signed declaration of the applicant saying that they have such intent. Now, then let's maybe move on to the next slide and we can go into a little bit more detail. So who can apply and how long does the E-2 visa last? So as noted before, the E-2 visa is a non-immigrant visa which allows nationals of certain countries to come to the United States to develop and direct the operations of an enterprise in which they have invested. And you do have the option to either purchase a business that is already existing in the United States or to start up your new business. Now, you need to be a national of a treaty country to be able to qualify for the E-2 visa. And you can either, go to Google and search for treaty countries, Department of State, and you will see a list that comes up. And also we have the list of treaty countries in our blog. You can go to the Scott Legal website, and we do have a post covering this topic. But you will see a complete list of participating countries in the E-2 treaty. And this really includes a wide variety of countries in Europe, Asia, Africa, Latin America, Middle East. And, some common examples are UK, Mexico, Canada, Chile, the Philippines. And it is worth noting that this list is updated from time to time as those treaty relationships can change. For example, Israel was added relatively recently to the E-2 list. Some notable examples of countries that do not participate in the E-2 include China and India and Russia. Those countries do not participate, so nationals of China, India, and Russia cannot apply for the E-2 visa. However, it is worth noting that national here means you have a passport from that country. So for example, if you are a dual citizen, for example, a dual citizen of India and Canada, for example, you could qualify for the E-2 using your Canadian passport. So this does not depend on the country of birth, like the green card categories. So the next question to discuss is then how long does an E-2 visa last for? And so for this really depends on your country of nationality, because this depends on what is called the reciprocity schedule. So for many countries, the E-2 visa, if you get it, is valid for up to 5 years. But in some country cases, the validity of the visa itself can be as short as 3 months. And now what does this mean though? So the length of the E-2 visa is different from the length of the E-2 status, which you are given upon entry. So even if you're given a 3-month valid visa, as long as you enter the US during that period, once at entry at the US, you would be given 2 years to, stay in the US and develop your business, up to 2 years, and then you can leave. And then you would need a new visa to enter the United States because your 3 months visa would have expired by then. But it is really worth noting that the validity of the visa itself is the time period in which you can apply for admission, and it necessarily does not correspond to the time you're given once you are in the United States to develop and direct your business. Okay, so then let's maybe move on to the next topic then, which is probably a topic that many of you are curious about, is how much investment then is enough to qualify for an E-2 visa. And as I mentioned before, there is no a hard minimum number in regulations or law, but the requirement is that the investment must be substantial. And exactly how much money is substantial will really depend on the type of business being started. So let's talk a little bit about startup companies. So let's say you are setting up an office type consulting business, a service-oriented business, for example. Such businesses will likely require a lower amount to start up. For example, let's say $80,000, because there are not that many upfront costs to start. For example, you would, sign a business lease for commercial space where you can operate your office and meet clients or things like that. You could buy computer equipment so that you can provide those services, or you may buy some furniture for the office, or you may spend some money on marketing. Now, this inquiry is different for different types of businesses, such as if you're setting up a restaurant, or if you're setting up a manufacturing company, or if you're setting up a retail store. Those types of businesses typically require a higher amount to set up. And so, and the reasons why is because you typically need to secure more expensive equipment, machinery, for example. You typically need a larger space to warehouse inventory, things like that. So consulates would expect that you would have spent more money to set up the business and for the investment to be substantial. So, and relevant to this is the proportionality test. So the smaller the total cost needed to set up or purchase a business, the higher proportion of these costs must already have been spent. So for example, in the examples that we discussed, a small consulting company that only requires $80,000 to set up or purchase, the government would expect that the applicant has already spent 100% of that $80,000 that is required. By contrast, let's say you are investing in a manufacturing business that requires 10 million to fully set up. If you have spent 1 million towards the 10 million, even though you've only spent 10% of all the funds required to set up the business, that is likely to qualify as a substantial investment for the purposes of getting the E-2 visa. Now then, let's talk about situations where you are buying a business, not setting up a business. And in that case, you would compare the cost of buying the business to the fair market value of the business in the open market. So if you bought the business, in the open market and it's not a related party transaction, for example, and you likely pay the fair market value, and the value you paid to purchase the business is likely to be considered a substantial investment. And before I move on, I think it is very important to note here that different consulates around the world have different standards on what they would see as a substantial investment. So some consulates would consider any investment below 100,000 to not be enough to qualify for an E-2 visa. While other consulates around the world could consider investments as low as 50,000 to be sufficient in some cases, and we'll talk more about those cases. So it is very important to work with a law firm that understands these nuances and can guide you appropriately. All right, so we can move on to the next slide. All right, so then what are some of the strategies we can use to deal with the lower investment amount? So the first advice that we would give is really to ask, what is the overall strength of the E-2 application? And by that, I mean, if the other aspects of the case are strong, then you could be okay with a lower investment amount. Now, for example, if you have very strong evidence supporting that the company is real and operating, which means the company is ready to go, Let's say you have letters of intent from clients to retain your services once your E-2 visa is approved, or if you already have contracts or purchase orders from clients for the goods or services, or if you can get letters from local organizations such as the Chamber of Commerce supporting your business, or if you have already hired a U.S. employee and the business is already generating income. Those kinds of facts really strengthen the other parts of the E-2 requirements such that it could offset the lower investment amount that you have. And for those, and another strategy is to really make sure that you have a strong business plan showing that your business has very strong profit generation potential. And with regards to hiring U.S. employees before you apply, I wanted to emphasize that it is certainly not a requirement to hire U.S. employees before you apply for the E-2 visa to qualify for the visa. But if you are able to hire U.S. employees, that can certainly strengthen the case, especially if other aspects of the case are weaker. So now let's look at 2 examples then. So for the first example, let's say you are setting up a new business, and let's say you invested $50,000 in total. But let's say you already hired 2 employees and the business is already taking revenue. And the revenue is quite high, $80,000 per month. And let's say you already have clients, 10 clients who are already using your services or buying your products. In this kind of case, even though the investment amount is low, $50,000, we are seeing a very good case here for E-2 approval. And the reason why is because the profit generation and employee hiring potentials are high. And there are plenty of evidences that show why this business is real and operating and is not marginal. Now, let's consider a second example. Let's say you invested the same amount, $50,000, but there are no other strengthening factors. So the investment amount is low, but you don't want to invest any more money and you don't want to hire anyone until your E-2 is approved. And so you have not taken any action to develop the business further. And let's say you don't have any evidence that there is existing demand for your services by way of client interest letters or client contracts. In such a case, it is a little riskier. And the reason why is because the consulate, when they're looking at your case, could find that not enough has been done to really allow the business to be real and operating and to generate enough profits to meet the requirements for the E-2 visa. So in that case, yes, certainly a more risky fact pattern. All right, so now then let's move on to the next topic. And we can go over what are some common E-2 visa expenditures to meet the investment requirement for the E-2 visa. So you can see here a list of common expenditures that we see, and really, it ranges the gamut. You would really think of what are some legitimate investments that really is required to set up your business. So you can think about setting up your business office space. You can think about buying equipment for your office, or equipment that you need to operate your business. You can think about marketing and advertising fees to really generate the interest in your business. You can think about licensing fees if a license is required to operate in that particular field. You can think about employee payroll setup costs and also any payroll that you pay to employees if you hire employees before applying for your visa. Accounting services fees if you hire an accountant to take care of the business operations, or if you buy software, things like that. All of those can be relevant investments for setting up your business. Equipment, such as, and these can include computers, printers, scanners, all the typical office business expenditures, office supplies, furniture, such as desks and chairs. All of those things can be relevant when you're thinking of what areas you can spend money on. Now, are there good expenditures and bad expenditures, or can anything that I spend in relation to the business can apply as boosting up my investment amount? And the answer is yes, there are good expenditures and bad expenditures. So let's talk a little bit first about strong expenditures. One good category you can spend money on is marketing expenses. For example, if you set up your business website, if you set up fees, if you incurred fees for hosting that website, all of those things are related to marketing and business development, and those are typically helpful expenditures that count as investment. What about a commercial lease agreement for your office space? If you sign up for a space to host your business, there can be an option to prepay rent, which can boost your expenditure amount, because when you're applying for the E-2 visa, you can only include amounts that you have actually paid, and you cannot include amounts that you will be paying in the future. That is also a common misconception that we see that some clients have. Computer equipment, printing equipment, and scanners, as I mentioned before, those can be good expenditures, very relevant, clearly relevant to business purposes. If you are setting up a retail business, purchase of inventory can also be a good expenditure. IP trademarks, if those are needed for a business, payroll expenses, and any remuneration paid to employees are good expenditures. If you hired a lawyer to start up your business, legal fees can also be included. Any fees that you paid for business entity setup, for incorporation, for example, those can also be added. And finally, if you have applied for a license to operate in your particular field, you can include the licensing fees, as part of your investment. Now then, we can move on to the next slide and talk about what are some weaker expenditures that may not look good for your application. So before I go on to the list, let me talk a little bit about vehicles. So really, it's a fact-specific inquiry if buying a vehicle could work as a part of your expenditure schedule. If there is a business need to transport equipment or personnel, and depending on the type of your business, let's say you have a cleaning service and you need to go from place to place to provide those services, this could be relevant. But usually buying a vehicle, it does not work if it is just for the owner's personal convenience to go to and fro from work. And with a similar vein, travel-related expenses, such as airfare, if you buy your flights to come to the US to explore business opportunities or set up your business, the airfare will not count as a legitimate expenditure for business investment. And in the same vein, even if you spend money on client meals and entertainment, those are usually disfavored to be included in your business expenses. Similarly, any expenses that are directly reimbursed by a client or customer at the end. So if you are spending money to pre-book certain arrangements on behalf of future clients and they will eventually pay you back for that, this is not a good expense to count as your business investment. Lastly, any expenses that are paid to related parties. So for example, if your brother is a web designer and you pay your brother to design your website, maybe not the best expenditure to rely on as a legitimate business investment. All right, so to shift gears a little bit, then let's talk a little bit about some common types of businesses that pose a little bit higher risk in applying for an E-2 visa. So consulting businesses. And this type of business is actually very common. We handle a high number of consulting businesses. And a very common question that we get from clients is that realistically, that you have spent everything that you have, that you actually need to spend to set up the business, but I have nothing more to spend on. And a lot of our clients struggle with increasing the investment amount to apply for the visa. And it is true that theoretically, you can open a consultancy with only a few $100s from a business perspective. You can, set up a desk and a laptop and you have your expertise and you are doing the consulting. So really, you may not really need much else to launch the business from a business perspective. However, from an E-2 visa perspective, it will not work because the consulate will expect that you have spent at least a certain amount of funds to qualify as a substantial investment. So that is the challenge. we do recommend spending at least $40,000 on concrete expenditures. And in addition to that, have additional money reserved as working capital in the business bank account, such that you can increase the total investment amount. And with regards to the investment amount, it really depends on the consulate you're applying to. So we really do recommend that you speak with us to really consider your particular circumstances. And it is also worth noting that USCIS is open to slightly lower amounts of expenses. So if you're applying for a change of status through USCIS, then you could get away with a lower investment amount as well. So one advice that we would give to clients who are setting up a consultancy, who is struggling to find more expenditures to boost their investment amount, is really spend on things that you wouldn't have spent yet, but because you don't need right now, but you may need in the future. So basically sort of fronting the investment to buy those supplies or to make those expenditures that you may need in the future. For example, an extra laptop for an employee that you may hire at year 2 that you don't need to really spend until year 2, but you would, instead invest all of these funds upfront to make sure that you have enough expenditures to qualify for the E-2 visa. And the same argument goes for office space. You may not need office space for day one when you're setting up your consultancy, and you may only be using the office when you have developed your business to a certain degree, but it is always an option to prepay for such office space and have it set up earlier than you would have, because it just makes more sense to qualify for the E-2 visa. And in another vein, you could also consider spending more on things that already make sense for a business and that would really actually help your business growth. For example, you may not normally have designed a robust website or hired a PR firm to handle marketing, but you could consider doing these things because A, it is good for your business itself and generate, more interest among customers, and B, because it actually does increase your investment amount and will be more advantageous for you in applying for the E-2 visa. Another risk for consulting businesses is that there is a risk that the consular officer may think you will just work as a solo consultant instead of operating a business. So, and by that, the risk is that that the consular officer may think you may not hire additional employees other than yourself, and that you would, instead of managing your business, that you would just be providing consulting services on your own. So it would be more like a sole practitioner instead of running a business. And to counter those kinds of risk, it can be very helpful to procure letters of intent from clients or even sign contracts with clients beforehand to show that there is sufficient business out there to have your consultancy business generating enough revenue to be able to hire more people. So in that case, business development prior to applying for the E-2 visa could be a very good idea. Or another way you could counter this risk is to hire employees before you file the application. So as I noted before, for an E-2 visa, it is not a requirement to already have employees in the United States. But if you do have employees, it certainly helps your application, and it can strengthen applications where the investment amount is low. So this is one thing you can consider. You can even hire a part-time employee if you don't have the wherewithal to hire a full-time employee. Another risky fact pattern for a consulting company, before we move on to the next one, is if you only have one large client. So, and we see certain cases like this if the consultant was previously employed for a larger corporation as an employee capacity, perhaps an H-1B didn't work out. So they are proposing to come in as an E-2 investor, set up a consulting company, and really provide services to that one big, large corporate client that they previously worked at. So that kind of fact pattern is also risky. And And the reason why it's risky is because consular officers sort of see through that structure. And the way to counter this risk is really to, expand your reach to more clients. So you can try to get letters of intent from multiple clients to really show that not only are you providing services to this client, but you are providing services to multiple clients, and you will be hiring employees, and it won't be just yourself working to provide those services. All right, so now we can move on to the next type of business, which is real estate investment companies. So let's say that you created an LLC and you purchase real estate in the United States and you're collecting rental income. The question goes, can I apply for an E-2 visa for that kind of profit generating arrangement? And the answer is no. So if the purpose of the LLC is just to own property, and let's say you do some house flipping with that, and then you sell it, and then you buy more properties and then you sell it, those kinds of activities would not qualify for the E-2 visa. And the reason why is because those types of activities for real estate investments really looks like it's a passive investment. And for example, if you're holding property for appreciation and value, you're not providing active services, or are producing products and distributing those products. It's not a real and active operation, so that wouldn't work for the E-2. It doesn't align with the purpose of the E-2 visa. So you really need to show that your business is a real and operating business, as opposed to a passive investment where you own property and you hold it or you flip it for appreciation and value. So some examples that actually can work can include if you're setting up a real estate brokerage firm, for example, or if you set up a real estate management company and you're providing property management not only for your properties, but for many different clients from outside your own properties. Or let's say you're setting up a renovation or construction company and you will be providing these services for multiple outside clients. House flipping, this can work, but only if it is in a large scale and it can really be characterized as a commercial endeavor. So, for example, if you have 30 or 40 properties that you're flipping on a large scale, that can be considered a commercial enterprise, and evidently in this kind of case, the investment amount will need to be higher. But if it is just you yourself owning maybe 1 or 2 properties at a time, and then you'll be flipping and selling them for profit, that kind of arrangement is likely not work, because for that fact pattern, it really seems like it will be a passive investment, not a real and operating commercial business enterprise. Another thing that I would like to mention before we move on from real estate companies is that real estate investment, the real estate industry as a whole is a very regulated industry. So within each state, there are many licensing requirements that you may need to meet. So you would either need to already have that license, or you would need to contract with somebody who already has that license, depending on that particular state, such that you can show that your company is ready to hit the ground running. Otherwise, the consular officer may think that your company is not ready to actually be a real and operating, and your visa could be denied because of that reason. All right, so for the next slide then, equity trading companies. Now, this is another type of business that could pose risks for an E-2 visa. And the logic is quite similar to real estate. So just placing stock in an LLC, for example, and trading in a smaller scale for your own appreciation in value, that will not qualify as a business. And this can really be seen as passive trading for appreciation in value, and not be considered as an active, real and operating business. And if you really want to pursue the E-2 visa as an equity trading business, you really need to show interest from clients, from many clients outside of your own family or your immediate circle, so such that the business is not just doing these trading activities for yourself or your family, but you're doing it on a commercial scale. And another thing to note is that equity trading is a very heavily regulated industry as well, like the real estate industry is. So you would need to do significant due diligence. You would need to make sure that you have complied with all licensing requirements or business structuring requirements that comes with equity trading. And you would need to explain all of this clearly in the business plan and to the consular officer at the time of your interview. All right, so we can move on to the next slide then. So now let's discuss a little bit, what are some of the reasons why E-2 visa applications are denied? So the first reason and major reason is for low investment amount. And as I mentioned before, there are ways to strengthen cases that have low investment amounts, but there are some instances where the investment amount is just too low, and where the consular officer will see the low amount and they ultimately will deny the case. And if that is the case, there are several things you can do. You can spend more money and reapply. You can find other things you can spend on, or you can also have an independent accountant, for example, write a letter and confirm that the investment amount is sufficient for starting up that type of business. So there are some ways that you can bolster the strength of the case if low investment amount is the reason why your E-2 is denied. Another reason why an E-2 application can be denied is because of the nature of the business. And as I mentioned before, real estate businesses, equity trading businesses are riskier types of businesses. And an officer may not be familiar with what you're planning to do with that kind of enterprise or think that it's a viable business. In those cases, a business plan will be the key to explain exactly what you're proposing to do and how you will be hiring U.S. employees and supporting commercial activity through your business activity. Filing location and venue. So this is another very important reason why certain E-2 application could be denied. You do need to know your venue. We are seeing some changes in adjudication patterns as staffing changes. So definitely speak to your attorney for the most up-to-date information. Different venues, different consulates have different standards on what counts as a substantial investment. So this is a very important consideration you should have when you're preparing your E-2 case. Do you meet the marginality requirement? Will the business generate enough income to support U.S. employees? That is another common reason why E-2 visas can be denied. The E-2 visa is really not meant for a solo practitioner. So your business needs to project that it'll generate enough income to support more than the investor and their family with the business. So for example, let's say you already worked as a consultant and you were a solo consultant for many years in your home country. And you're applying to set up a consultancy business in the United States. The consular officer can think, well, if you operated as a solo consultant for so many years, then how do I know that you're going to generate enough business to support additional employees other than yourself in the United States? So in this kind of fact pattern, it could be a good idea to go ahead and hire 1 or 2 employees before you apply to preempt those kinds of skepticism that you can get from the consular officer. So it could be a good idea in such a fact pattern to mitigate such risks. Issues with adjudicating officers. So consular officers have a lot of discretion in deciding whether to grant a visa, and they are not reviewable by a court. So, and it is important to note that some consular officers, sometimes they just have a bad day. They're human beings. They can take a particular impression about your case and they may not be moved. It is always possible to reapply if you had a particularly negative encounter with a particular officer, and it is likely that you will get a different officer when you do reapply. So that can be one approach to handle those kinds of denials. So finally, if you just simply did not meet the requirements at the time of filing, that can be a reason for denial. So for example, if you don't meet the ownership requirement, if the E-2 company is not majority owned by treaty country nationals, or for example, if you plainly did not make a substantial investment, let's say you have spent $2,000 and you put $98,000 in your business bank account, that will certainly not work, because you have not committed enough funds, put enough funds at risk. And in those kinds of cases, you would rearrange how you are allocating those investments, and then you would reapply and you could get approved in a future time. All right, so moving on to the next slide then. E-2 adjudication trends and hot topics. So how has things changed after COVID? And have consulates been processing E-2 visas again after COVID? So yes, consulates have come back online to process E-2 visas with varying degrees depending on the consulate. And some consulates are still a little less staffed than other consulates are. With regards to Toronto and London, which are the two most common consulate that we work with, they have returned to processing visas in a reasonable time frame. They are still a bit slower than before COVID, and this trend is likely to continue for a bit, but we have seen vast improvements compared to 2021, for example. And it is very important to note that timelines are different between consulates as of now. So for example, in Turkey, it can take over a year to get an appointment. But for example, for Toronto, we have seen that they are reviewing cases in about 10 business days, and you can get an appointment in about 2 months. So we have seen quite an improvement there. If you are already in the United States, so if you're already in an E-2 status already, or if you are in a different status, such as a B or an F, you can file a petition with USCIS to change status. So if you're already on E-2 status, you can extend your E-2 status, or you can apply to change status to E-2 if you're in a different status. You can file a change of status petition to do that. Now, if you apply through USCIS, you can opt for premium processing, which can get you a decision within 15 calendar days. So there is certainly more predictability about timing and how soon you can get a response. But there are some downsides to this. So a change of status does not give you the ability to travel in and out of the US after you obtain that status. And you do need to separately apply for a visa stamp from a consulate to be able to leave and re-enter the United States again. And this will be a new E-2 petition at the consulate. So it is not like an H-1B where the USCIS approval is controlling. Each consulate will look at the E-2 petition as a fresh petition. So that is something to keep in mind. Also, another downside is that when you're applying through USCIS, USCIS is very strict about the source and trail of funds. So USCIS looks for a dollar-to-dollar accounting on exactly where the money came from and how the money has accumulated and how the money has been transferred. By contrast, consular officers will take a more high-level approach when they're looking at the source of funds. So, and you can usually be okay if you show, for example, tax returns showing employment income, and then you show the transfer of money from your bank account to the business bank account. That can usually be sufficient proof. But USCIS will look for more than that. All right, so let's move on to the next slide then. Issues in complex areas that come up with E-2 visas. So here, let's go over some common questions. Do I have to hire employees before applying for an E-2 visa? So the answer is no, it is not a requirement. However, as I explained in previous slides, it can certainly help your case if you hire an employee, especially if your investment amount is low. Complicated source and trail of funds. This can pose a challenge, especially if you are applying through USCIS for a change of status. If it is difficult to track the origin or source of the money you invested, perhaps if you don't have documentation readily available, or perhaps if it was sourced from many different accounts at many different various timeframes, this can be challenging to really show the trail of all of the money, where all of the money came from. Now, with regards to the source of funds, it is possible to source the money through loans or gifts. And it is okay to get loans or gifts from related parties, such as your relatives. But in such case, there are requirements that you need to think about. So the first requirement is you need to document the source of that loan. So if it is a loan, you would get the loan agreement, and you would show the terms of the loan, who is loaning to who, how much money is loaned, and what are the terms of repayment. The second thing to consider is that the loan cannot be secured by assets that are owned by the E2 business or secured by the E2 business itself. So this means either this should be an unsecured loan, like a line of credit, or it can be secured by other property, such as personal real estate, unrelated to the E2 business. If it is a personal loan, you should also show the source of where the loaner got their money. So, for example, if you get a 50K loan from your uncle, you need to show where your uncle earned the 50K. So if the uncle pull that money from his savings account, you would need to show how he earned that money in that savings account. For maybe, for example, from employment, you would need to show then tax returns of your uncle to show that your uncle has earned sufficient income to support the accumulation of this money. And the same thing goes with gifts. So you would document the source of the gift, and you would have the gifter write a gift letter explaining who is gifting money to whom, how much money is gifted, and that there is no expectation of repayment. And especially if you're applying through USCIS, you would need to show the source of funds of where the gifter got the money. So, and a similar inquiry would go in as what I just explained before with regards to the personal loan. All right. E2 visas for two investors where the ownership is 50-50. So it is possible to apply for E2 visas with two investors who both each 50% of the company, right? Provided that both investors are treaty country nationals. Okay, but one thing that you should note is that each person must separately meet the substantial investment requirement. So for example, you can't have one investor only invest 20K and the other investor invest 80K, right? Because only one person will be deemed to have made a substantial investment, whereas the other person only invested 20K, and that will not count as a substantial investment. So that is something that you should take into consideration. Substantive changes to the E2 business after filing the E2. So this is very important to think about compliance after you do come to the United States and after you start running your business. You do need to maintain 50% or above in ownership of the business. Otherwise, you are no longer eligible for E2 status. Substantial changes in the type of business after you get the visa needs to be approved by the consulate. So for example, if you set up a consulting company, you cannot just expand into the restaurant business, as that is not related to the initial business plan that you applied for the E2 with. And another thing to emphasize is that you cannot work for any other company but your specific E2 entity that you applied with. Family business purchases. So purchasing a business from family. So this can be risky. And the reason why is because the government can think that it is not a real bona fide transaction. It is possible to apply with such a transaction, but you do need additional evidence to back up the fact that it is a bona fide transaction, such as an independent accountant evaluation, for example, that confirms that the business price reflects the fair market price for that particular business. Okay. So I think that is all I had to present today. And let's see if anyone has any questions.
Yeah, so I think we've come to the end of the presentation. GA, thank you so much for sharing your insight. It doesn't look like any questions came in, so I think we will close here. But thank you so much for this information.
Thanks,
Have
everyone.
a great day.
Bye.
Bye.